In the item number 5, we have filed an additional affidavit. I say, my lord, it may be postponed.
Huh?
Item number 5, an additional affidavit.
You call?
My lord, another matter, my lord, will file 28th of April, my lord. It may come up on 14th. As motion.
No.
14th.
Later. Got a lot of matters, no?
Blacklisting matter, my lord.
You see, actually, we are not allowing. I'm allowing here this bench. No, in other benches we have stopped.
Anyway, my lord.
90.
Lord, I did to mention for listing a case my on 15th of this month.
For new matter. New matter.
Since 1 year back, it's not listed, man. Even the matter.
I think we'll have to follow the same thing, I think from now on. From next week, I'm not going to allow any mentions except for new matters. This will be the last date. You'll have to go to the registry as is being done in the other court. There's a matter on 21.
Okay.
My lord, I'd like to mention a new matter, my lord. This is regarding cancellation of my permit of my stone quarry, my lord. So, Lordship, my Tuesday or Wednesday, my lord.
When?
Next Tuesday, my lord. Okay.
I'm also praying for listing of a matter, settlement matter, my lord. Lordship allowed me actually for listing on 7th. The 7th was declared holiday. That is why, my lord, once again, I have mentioned this matter.
When? Oh. When do you want?
Any day in the next week, my lord.
They're going to list. That's what I've been told. Wednesday
16th?
matters all.
On 16th?
Okay. Okay.
16, my lord.
Yeah, please, my lord. My lord, I'm praying for listing of a review petition, my lord. Can it be fixed on 14?
Review.
Review. I'm obliged.
Lordship, I got to mention for a WPC matter for listing a lordship. It was last listed on 18th of December 2020.
Give a date.
No, please, Lordship. Lordship, a contempt matter regarding admitted amount matter. Any date you have.
Give after 23rd, 24th, 25th.
Give, please.
So, my prayer is for a listing lordship 19th May lordship.
What?
Regarding
Yes. What's your name, madam?
listing
Why after so many years, order was passed in 2019, madam?
Section paragraph number 7.
Have you? There is paragraph number 7. Madam, have you read the section 20 of the Contents of Courts Act? Anyway, since no time limit is provided. Miss, your name? Huh? Yes, Devlan, counsel for the petitioner who submits that the respondents have not verified the contractual dues payable to the petitioner in terms of the order dated 1/11/19 passed in WPC 1291 of 2015. Issue notice returnable in 4 weeks. Petitioner takes steps within 3 days. This is the matter of the police. Yes, madam. What is your name?
K. Bhattacharya
On behalf of
or G.J. Sharma, Advocate G.J. Sharma.
Dr. G.J. Sharma. I got the name. Who submits that the petitioner's contractual dues have not been paid in terms of the order dated 29/4/24 passed in WPC 4071 of 24. Same thing, huh? After 4 weeks. Step within 3 days.
So there was a direction to dispose of the appeal Page 11 only is the operative part.
Yes, we issue notice.
My lord.
Heard Mr. H. Gupta, learned counsel for the petitioner who submits that the petitioner's appeal, which was filed on 27/1/25 before the District Commissioner Nagong, has not been disposed of, has not been decided this despite the order dated 20/01/25 passed in WPC 192 of 2025. Issue notice 4 weeks. That steps to date, clear the matter of. Not considered. Right, heard Mr. I. Shaikh, learned counsel for the petitioner, who submits that the petitioner's prayer for shifting of his IMFL off shop has not been considered till date by the respondent, despite the order dated 5/3/25 passed in WPC 78 of 25. Notice 4 weeks, steps 2 days out of 4.
This may be, that's for timing, my lord. Please watch it. This is the second reason, my lord. The lordship has passed so many other kind of,
Huh?
the lordship has passed so many orders regarding this issue.
Yeah.
And beyond that 6 months time for compliance. Not even the mass, even has not been made.
Not complied with.
No, madam.
Huh?
No, madam, their payment has not been made.
Item number,
Yes, madam. Item number 6,
item number 6.
madam.
So, so then, where is the last order?
The last order is 33,
Yes,
last paragraph, madam.
yes.
Page 37, madam.
Now, when was the order passed?
This order was passed on 20 March 2024,
20,
madam.
March,
Madam,
24th March.
madam.
And now how many days have 24th March? That is more than,
More than a year, madam.
yes.
They are
Within
doing
the 6
paperwork.
months' time. Now the issue is, when a court has already passed a direction and that has not been obeyed, what is the logical thing to do?
I have file contempt,
Then,
but I have prepared this, madam.
no, then where's the question of contempt? I mean, where's the question of filing the same writ petition, the same order? There's nothing, this writ petition is not maintainable. I can understand if the contempt period has expired and there's a delay in filing a contempt. I can understand, but that's not the case here.
Not will file the contempt. I'll do this.
You want to withdraw or what? Mr. S. P. Das, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition. Mr. S. Bora appears for the petitioner. For the respondent, all the respondents. All respondents. The prayer of the petitioner's counsel is allowed, the petitioner is dismissed as withdrawn.
Followed here, this one of the petitioner is herself with voter since 70 onwards.
Huh?
The petitioner is herself with voter in 1970 onwards.
He is a voter since 1970 onwards.
My lord. But she has been made the voter in 2005, my lord. 2005 onwards, she has been marked as the voter.
In 2005.
2005.
Huh.
And the inquiry has been made in the office of the Superintendent of Police, Kolkata, whether any FT case or the voter case is registered against her or not. And the SPB Kolkata says that no case is pending against this lady. So, my lord, but voter list is demarked.
Where is the SP letter?
My lord, at page 30.
Page 30.
My lord, NSS 7. But B is continued to remain.
2019, okay.
My lord.
My lord, I have given my lord similar order. To conduct an inquiry. If, verification is, not to be a demoted, then this should be removed. Or if not.
So it has to
satisfied-
be, it has to go to the foreigners tribunal to decide.
My lord, reference should be made by the SPB Golpara. He should, my lord, make a verification.
Golpara.
Golpara. And if on the verification, they are not, if not satisfied, then maybe, then only, reference, otherwise not.
Okay, heard Mr.
ARC.
A.R. Singh, learned counsel for the petitioner. And Mr.
H. Puri, on behalf of Mr. AIL for the election.
H.
H. Puri, my lord.
Puli,
Yes,
on behalf of
Mr. AIL
A.I. Ali, learned counsel for the
election.
respondents number
Respondent number 5.
5 only.
Election officer here, and maybe also appear for election, respondent number 4. Election officer. 4 and 5.
4 and 5. Mr. G. Bokaliel appears for 2, 3 and 6. Who else? That's all. What about 1? Huh? Who is for 1? Mr. S.S. Roy, you're for 1. S.S. Roy appears for number. The case of the petitioner is that the petitioner was always in the voters list from 1970 onwards. For which constituency?
My lord.
For which area?
My lord, 70 total list at page 17. Page 17. My name is
Voters list in respect of,
Rupanu Nessa.
huh?
My name is Rupanu Nessa. 70 total list.
The district Golpara, subdivision Golpara, PS Lakshipur, village 311, Kangai Pachimpara.
Kangai.
Kangai Pachimpara, Lakshipur. Page 17, huh? Since 1970 onwards. Pustak. However, the name of the petitioner was marked with the letter D
In the year 2005.
in the year 2005. Pustak. On approaching the concerned respondent authorities for removal of the tag D from his name in the voters list, an inquiry was initiated by the superintendent of police B, capital B, Golpara.
At page 32.
That is respondent number 6. The respondent number 6 thereafter wrote a letter dated 4/7/2019 to the election officer Golpara, stating that as per records available in his office, there is no record of any foreigners tribunal or de-voter case. Next, council submits that as the concerned authorities have an appropriate direction be issued to the authorities so that the petition is removed. Okay, then para 4, para 5. Para 6, para 7, para 8. That's all.
My. Standing at 5.
Let's see what we see now. In the additional affidavit, to say, it is not the dealer since 2008. And now, on 31/5/22, my lord, he upgradation and replacement of pulsar.
Just a minute, 1 minute. Let me turn the pages and all. Yes,
My lord, yes, what happened, my lord? On 31/5/22, these two pulsars were upgraded and replaced. That we have annexed at page 396, 398. In the additional
what was replaced?
pulsars,
Okay.
two pulsars. And since from the very day, my lord, 31/5, my lord, problems started. We filed, my lord, various complaints, my lord, I have annexed all these complaints. My lord, since then. These are, my lord, all 400, page 400 to 418, my lord. All complaints are, my lord, continuously, my lord, we are facing problem. After, my lord, the pulsars were replaced, my lord,
In 2022.
31/5/22.
Replaced by whom?
Replaced by the company, my lord.
Which, the company or the manufacturer of the pulsar?
It says, well, the original equipment manufacturer.
Huh?
Original equipment manufacturer.
Who is the original equipment manufacturer?
Gilberto.
Huh? Gilbert. GSR, GVR,
Yes.
GVR. So replaced by GVR.
But the PO belongs to the Gilberto.
What?
The dispensing unit belongs to, well, the original.
Dispensing unit belongs to GVR. And GVR is the manufacturer of this dispensing unit. Correct?
Then ultimately, my lord, on 4/11/22, my lord, this is also important. 4/11/22, the meter was replaced and AI nozzle configuration was done.
4/11/22 meter replaced.
Meter was replaced,
By whom?
GBR. That is at page 419, my lord. I have annexed. For 1 minute.
Are we, is this necessary to decide the issue?
Well, this is, my lord,
This is with regard to fact.
All maintainable or not, my lord?
no, why it is necessary, my lord, I am coming, my lord. Just a few minutes. my lord.
Yes, yes.
Now,
No
my lord, what happened? This recalibration of the nozzles was done on 29/5/23
Recalibration
was done.
of what?
Nozzles,
Nodules,
nozzles
nozzles,
was done.
nozzles of the pipe
By
were done on
29/5/23.
29/5/23. These are
These
all facts.
Yes.
What has that got to do anything with the issue at hand?
Now I am coming, mother. Now, this was 29/5, my lord. Now 14/7, GBR has, my lord, sent some mail that there is some error. in the
14,
14/7/23,
that
which is at page 88, my lord, original picture. Then the respondent.
what is the, GVR has said what, 14/7/23, what? That there is some problem with the nodules.
No, pulsar. Pulsar.
That is not what Mr. Bhaskar Datta had said on the last day.
When recalibration was done, my lord, on 29/5/23, no. Then 18/7, my lord, the respondent has issued the letter that the opening and packing the pulsars on 18/7.
No, those are all
My lord,
factual.
now,
There's
if
nothing
you
to
also
do.
see, my lord, that these were all sealed, my lord, by the legal material department. We have no hand. Page 101 may be seen, my lord. Just your losses may just see page 101. This is the inspector of legal metrology. Whenever they come, my lord, the inspector of legal metrology is always present because he always seal it. Now, if you also see second paragraph, therefore the undersigned would like to highlight the fact that during all such inspections, so far the DURO were checked using departmental capacity manager of 5 liter and accuracy delivered were found to be correct. Also during such inspection, a thorough check was made on the seals and wires found to be intact. We found nothing suspicious which may raise concern regarding an attempt of tampering with internal dispensing units. As such, the question of tampering the seals or manipulating key components inside you does not realize.
These are issues, these are factual issues. Are you asking this court to go into those issues?
My lord, my question is only, my lord, at one point of time, that the, everything is sealed. We have no
Yes.
hand to inside.
No. You see, now, leave that aside.
Yes.
Those are issues that will be gone into by the competent authority. Whether there has been some foul play in the dispensing unit or not, that is an issue to be decided by the authorities concerned. The issue here is somewhat different, I think.
Should here is, my lord, they say that pulsars were found to be, my lord.
I am not going, Mr. Counsel.
Yes.
You had gone to the commercial court.
My lord, that is, my lord,
No. What do you want in this writ petition? What is your prayer in this writ petition? Let us go to the, okay. If you don't want to answer it, let us go to the prayer. What do you want in this writ petition?
my lord, that on the history of the.
Stay. That is what you want. Not, you don't want this court to go into the issue of whether there was some hanky-panky done with your dispenser or nozzle or anything. That is not the issue. You want the stay of the termination order, correct? Now you have gone to the Supreme Court already.
Well, that is prior to that, my lord.
No, sorry. I think you've got the facts wrong. Tell me when did you go?
That is against the.
Please give me the Supreme Court order. Since you have, please give me the Supreme Court order. You are the one who had gone there. Please give me the Supreme Court order.
My lord, that is against the, my lord.
You have not put it here in this writ petition.
That is against the, my lord,
This will clarify everything.
that is, my
The
lord,
date when you went.
only, my lord, regarding the jurisdiction of the commercial court. That is at.
No, no.
But this is against my lord 5/21/24, passed by the my lord.
Actual
District Appellate Court.
In fact, my lord,
That appellate court, the appellate commercial court, that
Yes.
is the
my lord, that was
additional
also-
district judge.
That was also wrong, my lord, because district judge has no jurisdiction to entertain appeal.
Cannot go into
Well,
that. Those issues now will be decided as per the direction passed by the Supreme Court. Who am I to come between the Supreme Court and that appellate commercial court?
But actually, my lord, the Supreme Court had directed the district judge to hear the appeal.
Let us see, when was the order passed by the Supreme Court? Order was passed on 34/20/25. And when was your your dealership terminated?
12/4.
12/4.
Yes.
And did you bring it to the notice of the Supreme Court that your dealership was terminated on 12/4?
But that was in respect to another matter, my lord.
No,
That was
no, no.
another matter,
Please, tell me which matter.
my lord.
Tell me
But
which matter.
That was in respect of the commercial court order, my lord. Not, the termination was not the issue there. my lord.
No. Sorry. When the show cause notice was issued to you
Yes.
by the Numaligarh, the BPCL, by the BPCL, then you filed a reply.
Yes.
And you had also gone to the commercial court and asked for a stay.
Yes.
You were asked for injunction, not so that they would not issue any order against you. Accordingly, there was a restraining order passed by the commercial court because you were scared that a termination order would ensue.
But termination order was not a subject matter, my lord, there.
It was a subject matter.
Yes.
That's why you went to the commercial
I have the
court.
copy.
Otherwise, what is the reason to go to the commercial court?
Termination matter only, my lord, that the subsequent lord action.
No case, Mr. Anand.
My lord, I'm submitting, my lord, another aspect, my lord,
Yes.
that we may be allowed to file an appeal against the order as per the.
I'm not doing anything. When
No,
the,
only thing, my lord, I pray, my lord, that sometimes
I'm-
still appeal is dispose of status quo will maintain. my lord.
no.
Status quo will-
Nothing.
My lord, because, my lord, otherwise. they will
Supreme, Supreme Court has already passed an order that if a request is made by the petitioner for expeditious disposal of the appeal before the commercial appellate court, the said request shall be considered in accordance with law, so.
My lord, that will
Now, I
help
am
us.
not going to go
My
beyond
lord,
that.
that will not help us, my lord, because,
How can I help it?
no.
How can I help? How can this court help?
my lord,
When there is a procedure to be followed and you are the one who started, you are the one who initiated the process by going to the commercial court.
My lord, only my lord,
Nothing remains.
my prayer is this, my lord, status and my.
No, no.
With that,
Let me hear this.
till that, appeal.
It is a clear classic
that
case of
will-
a forum shopping.
Huh?
It's a classic case of a forum shopping, my lord.
Forum shopping.
Yes.
Well,
Because my he did not get in.
he's got his back to, he's got his back to the wall now.
No, my lord. But the
It's
IA,
not forum shopping.
yes, but because the IA, which is in file, my lord, in commercial appellate division, my lord.
Which IA?
But IA has been filed in commercial appellate division.
Acha, he has filed
Yes,
IA.
yes, my lord.
Appeal was filed by you.
No, my lord.
No, in the commercial appellate court, it
Yes.
was filed by you.
Yes,
Appeal was filed by you. He has filed an IA.
No, man, they have tried against this order, my lord. They have again filed a commercial appeal.
Which, against which, the termination order.
No, my lord, against the lower court order, my lord, appellate court order. First, my lord, they have gone to commercial court.
They went to commercial court. Okay, commercial court gave the
Civil
restraining order. Then you went to the appellate
Appellate
commercial court.
Against the order, my lord, they have come to the provisional bench, my lord, High Court, my lord.
So,
So they are on the day of my lord, passing of the order, my lord, they have filed one IA, my lord. They are, my lord, they are pleadings and the pair are the same, my lord.
IA where?
Yes, my lord.
My lord,
This is the IA, my lord. They have an X, my lord. In a commercial appeal, my lord, which is being filed.
Acha, they against,
Yes. And
that's
the
what I'm
pleadings are-
saying. That's what I'm saying.
Yes.
You also confusing me. The appeal was filed by you. The
Yes.
application was filed by them.
Yes.
That's what I'm saying. The appeal was filed by you. You're saying no, he filed it. Yeah, please understand the difference between an appeal and an application.
Yes, sir.
You're confusing me.
No, no.
As it is, your writ petition is so thick. And so many steps it has gone. You have gone from here, there, everywhere you have
Yes,
gone.
because one of the notifications issued by the High Court, my lord.
Huh?
Because the confusion arises, my lord, as because the issuance of one notification, my lord.
I know.
Yes.
Because of that, they went to the commercial division here.
Yes, my lord.
And then later on, this court said,
Yes, my lord.
commercial division said, we have got no jurisdiction
Yes,
to entertain this issue.
Yes, ma'am. Then they have also, my lord, filed one IA, my lord.
Where?
In an application, yes.
This
sir.
one, this
Yes,
one.
yes, my
So
lord.
let me see.
Yes.
This I didn't know.
Yes, ma'am.
This is not mentioned there.
Yes, no, not that, sir, ma'am. The order has been annexed, my lord.
my lord, yes, it is there.
Okay.
And Section 11 is pending, my lord.
389, my lord.
Section 11?
They have also prepared a
one
Section 11 petition, my lord. Yeah. Which is also pending, my lord.
Acha, the arbitration.
Yes, ma'am.
That is pending.
Yes.
That's different.
Well, that is there, my lord, 389.
Look, what you are praying here, you have already prayed there.
Yes, my lord.
Can you have two parallel proceedings?
Well, that before the additional district judge or civil judge, that is prior to termination order.
But then it's still there, no? Nevertheless.
Yes.
And it is not prior to termination order. I don't think so.
No, that is. the
This
High Court.
is,
That is the High Court, my lord.
After termination, my lord.
no, huh?
That
After
is the High
termination, my
Court.
lord.
Acha, this is the High Court.
Yes, my lord.
That is High Court.
This is High Court. This is not
Yes, my
again
lord.
the.
The pleadings are the same, my lord.
Okay. No, that is a different thing. He asked there, they didn't have jurisdiction, so he's come here. How does it matter?
No, but the Section 11, the arbitration petition also pending. my lord.
Pending.
Yes, my lord. Is it
No, I'm not on that.
happy? There's a
So termination order,
My lord, otherwise they would give the on ad hoc basis, my lord, to somebody else, my lord.
maybe, but then I don't know. I cannot go into those issues.
my lord.
My lord, I pray only, my lord, for express.
See, the retail order has been consulted by us, my lord.
Huh?
The retail order has been consulted by us, my lord. We have given
Has
the-
been?
consulted by us, my lord.
Okay.
Is it
You are who? Who are you?
BPCL, my lord?
BPC.
Yes, my lord.
No, constructed by Numaligar,
Yes.
not by you.
Day after it was transferred to us, my lord. Now we are paying the lease amount monthly to the petitioner, my lord. And he has no right, my lord.
Anyway. Okay. I'll pass the order. Oh, what is this? What is this affidavit for?
Other checks I have.
No,
My lord. Yeah.
no.
My incident of July 2023, my lord, he annexed this up to my lord 31/5/2022, my lord.
What?
The extension he has filed, my lord.
Ah,
incident matter, the defects we say wants to.
I don't know. The basic thing is that now he can go to the appellate, commercial appellate court for
Yes, sir.
disposal of his appeal. That's all. Because Supreme Court has directed, I am not going to go beyond what Supreme Court has said. Even we are all bound by Supreme Court. Even I've got to obey the Supreme Court. I cannot go beyond that. Right. What is this two judgment? It had been given to us earlier by,
That is also not applicable, my lord. The conclusions on the interim,
okay,
I have one. I know also to my lord, that's very Supreme Court, my lord.
show me. Para,
Like, picture, page 3, my lord, onwards, page 7. 12. Then my 18, my lord.
hmm?
12 and 18, my lord. The 12 is also clear, my lord.
No, but I don't know, you see, anyway, that is not the issue, main issue here. But it'll be nice to have a closure on this aspect as to whether when an interim order is extended from time to time,
Yes, my lord.
and on the last date, till the day, on the date when it was to expire,
Yes, my lord.
the court reserves its judgment.
Yes, my lord.
Then what happens?
That is what my lord is written here.
Where does it, where is
Yes,
it?
May I read, my lord?
The relevant para.
Prayer table, the indisputably, this.
Para 3. Yes.
First one, the interim order was passed on 38 to 1997, madam. Then my prayer table, indisputably said interim order was extended from time to time, as will be notified after by an order the 24/9/1997, while adjourning the suit on 29/11/1997, an order of mistake date 30/1997 was extended. On 29/11/1997, the following order was passed. Case is adjourned to 9/1/1988 for filing of written statement and reply to the injunction application till the stay order to the so-and-so is extended. Yet again by order the so-and-so, the stay order was extended to 23/3/1988. Similar order was passed on 23/3/1988. The matter was, however, placed on 28/7/1988. The ground that projecting officer was to remain on leave on 29/7/1988. The matter was adjourned on 9/9/1988. However, the order of injunction was not extended. After some adjournment, the suit was dismissed for default on 19/8/2000. This one is normally the High Court objection of Para 7.
Para?
Para 7.
Yes.
A writ petition was filed for questioning the legality and the validity of the state direction reported Punjab and Haryana High Court, which was registered as so-and-so. By reason of the impugn order, same writ petition has been dismissed by the impugn bench of the High Court, entirely appealing. The position as explained in the writ petition appears to be correct simply because while adjourning the case, the presiding officer was not holding a court a day earlier the date fixed, where orders with regard to stay are silent, would not mean that stay was vacated. In any case remained pending after adjournment, as mentioned above. Gradually, it is a positive case for respondent that the stay was operative till such time, so was dismissed in the column 19/8/2000. Even otherwise, we are of the firm view that if once stay is granted and same is not specifically vacated, case is simply adjourned, it cannot be interpreted to mean that the stay was operative only after the date when the case was adjourned. Without passing any order with regard to extension or otherwise stay. Petitioner appears that intention to hold the order passed after the case was adjourned on 1928. Now, my para 12. Para 11. The short question was arises for consideration in the limits of the to whether the order of ad interim injunction granted by the learned the senior division Pani was operative till 9/9/1998 or to 9/8/2000. We have noticed here in above the nature of the orders passed by Lana Civil Judge, although in his order dated 30/1997, the Lana Civil Judge used the term in the meantime, which was repeated.
Well, this is slightly different. The issue is slightly
Now,
different.
para 12 में लगा लीजिए.
Yes.
But in the subsequent order, the beginning from a solution of the expression used still then. Here also, the honorable defense was used.
Maybe, but out here it was kept for, it was reserved for judgment.
But the term of order of the land does, in our opinion, does not leave any manner of doubt whatsoever that the interim order was only extended from time to time. The interim order having been extended in a particular date, the contents of date by the respondent hearing that they were under bona fide belief that the order was vacated cannot be accepted.
It's not really to the point. Out here on, say, an interim order is to be till tomorrow, say. Tomorrow this case matter is placed. I reserve it for judgment. What happens? Does it mean that the stay order dies
Because the
on
present case, madam.
tomorrow, or will it carry on till I pass the judgment?
Till tomorrow, madam.
Huh?
Till tomorrow, madam.
Till tomorrow, then they've got a case.
No, madam. So in the present case, my lord, the date was
Okay.
fixed, my lord.
Okay, till tomorrow only. That's what they're saying.
27 to the 25.
Anyway, that is the issue. That is the issue which I just want to know. It has got nothing to do with this case for the time being because of the Supreme Court
issue was
judgment.
defined, my lord. In Allahabad, my lord, I could buy a case, but the issue was defined, my lord. Whether interim order passed by the any other court, madam, will automatically vacate after expiry of 6 months or not. That is the issue, madam. That was the issue in the constitution bench, madam. So the issue are defined, madam.
Anyway. Mr. Goswami, just want to ask you a question. When there is an interim order passed by a court till a certain date, and on that certain date, parties are heard, and the case is fixed for, reserved for judgment on the said date, and the judgment is passed after, say, 2 months. Now, will that stay order which had been fixed for that particular date continue till the judgment is passed, or will it die a natural death on the date it was heard? On the date when it was, till the date it was fixed. Say I pass a stay order today, which I say till tomorrow. List the case tomorrow. Tomorrow I hear this matter. I reserve the matter for judgment for, say, 2 months, and after 2 months I pass the judgment. Now, as per the order passed today, it should die a natural death tomorrow if I don't extend it. Normally. But now, since I have kept it reserved for judgment, then what happens? Huh? Ha. But but there is no hard and there is no citations or some precedents, I think, with regard to this. Is it?
I go from my lord.
Huh? No, this I don't think is applicable. I don't think so. This is different, slightly different.
So in 13 to my,
Huh?
13 to 25 minutes, order was passed till my so date fixed.
Correct, out here also it is
Yes.
still till the
No,
next date.
up to my,
But on that date, the case was fixed for.
on that
Uh,
day, the interim order was
CAV.
not extended, madam.
Correct, because it was fixed for judgment. CAV, it was reserved.
So the earlier order, madam, is same by till then, madam.
Like supposing you two are say you two are, I'm going to hear your matter tomorrow. And I say interim order is till tomorrow.
Yes, madam.
Now, say tomorrow I said, and then instead of extending, I say that heard counsels, judgment reserved. Will it amount to, well, what will it amount to? It will, of course, there's no extension of the stay order. But by implication, would it mean that it should be extended because of the judgment that is to be pronounced? Possibly should, possibly should. Should, maybe. Anyway, that issue I just wanted to know because that issue could have been an issue, but now it's since Supreme Court has already passed an order. I'm not going to go beyond the Supreme Court order. It's just, but just troubling my mind. What should be the correct procedure?
Then when I said they have also filed a IM, madam.
Before the commercial division,
Court, madam.
commercial division of this bench,
Yes, madam.
of this court.
Yes, madam.
But this court did not have the jurisdiction to try
No,
the
but
matter.
they wanted to plead, madam, since the order has been automatically extended, madam.
So what is the wrong
Yes, madam.
in their coming and making a prayer here? Because the division bench, the division commercial bench did not have the jurisdiction to hear the matter or decide the issue.
Closed, madam. Now, madam, this court, madam.
IA was closed.
Yes, madam.
But then if it is closed by a court that does not have the jurisdiction to try the case, how the order passed is non-as.
Then again, he has to go to Supreme Court. But
No, that's why I'm not passing any order on that issue. He has to go to Supreme Court. But then
because
now,
the IM, madam,
so this order has clarified everything.
Yes.
I mean, this order is there.
Today's 40 days.
That is, I don't know. For this court, it's slightly difficult now. I think. Should have been actually, should have been. Should have been, but then now what to do? Now it's, I think, maybe, why don't you ask, since they have already been given the liberty to go there, you ask there. You go and ask there whether it's, whether you should be given a stay. Okay, right, heard Mr. G.S. Sahawala, learned senior counsel for the petitioner. And Mr.
As whatever.
S. Barthako, learned counsel for the
Sole responsibility.
sole respondent. Right. The The contents, the order dated 30/04/2025 passed by the Honorable Supreme Court in SLPC number 22359 slash 2025. On the other date, Mr. Bhaskar Datta had given me a different number. He had given me a number SLPC 12417 of 2025. 12417 of 2025. But this is different.
22359 of 25.
Oh. Okay, anyway, they've given me a wrong number. It should not be done. What have I said?
But para 34 here is there, 1, 2,
Huh?
34.
What is- Of the writ petition.
Yes, sir. One, 2, 4, 1, 7 of 20.
Ah, he's put it in para 34. This is wrong.
Well, this is, it appears in the diary number in our order. Subsequently, it might have been ordered, I don't know. I don't have knowledge.
And this order is not 23/4. Out there in para 34, it said 23/4. It is 30/04.
34.
Okay, this is no 30/04 is correct.
Yes.
That is by this court. Okay, whatever I said. Anyway, let it be. May make a mistake maybe. What have I said? Twenty 25 states as follows. Take it down. Okay. Pusta. Next. As the SLP filed by the petitioner has been dismissed with liberty being given to the petitioner for expeditious disposal of the appeal filed by the respondent, comma, that is misarbitration, no, that is that is misarbitration appeal number 9 of 2020, 9 of 2024. The said request shall be considered in accordance with law, and an endeavor shall be made to dispose of the appeal expeditiously as possible. This court is of the view that nothing that the prayer of the petitioner that no that the court is of the view that it would not be proper for this court to entertain this writ petition, as it would only lead to multiplicity of proceedings, which should not be in consonance with the directions passed by the Supreme Court. In view of the fact that the Supreme Court has dismissed the SLP, with liberty being given to the petitioner to approach the Commercial Appellate Court for early disposal of the appeal, the writ petition stands dismissed. Just the boy. You want this back? Huh? Only you return only this, nothing else. Uh, 359 of 2025. It is here. Yes,
The petitioners before your lordships are
item,
items A.
yes.
But the petitioners before your lordships, they are the residents of Central Destitute Home. They were provided shelter by the government of India, and subsequently this Central Destitute Home has been run under the supervision of the Social Welfare Department. Now, in recent times, my lord, the structures in which they have been provided their accommodation facilities by the concerned department. Now that has become deplorable, so much so that it has not remained suitable for human habitats. So these petitioners approached the authorities of the Central Destitute Home, praying for renovation. And in turn, the authority of the Central Destitute.
This is not your land,
No,
not your home?
no.
No, any right of yours has been violated?
My lord, here there is a right which is accrued out of that very scheme, which I have annexed. If your lordship kindly turns to page 98. This is the part of the scheme that is the Pradhan Mantri Awas Yojana for all. Now, as per this, there is one category beneficiary-led construction at page 98. Your lordship kindly sees the clause 5.1.2.
Yes,
In the case of landless beneficiaries, states, union territories at their own expenses may provide heritable but non-transferable land rights, pattas, to the families, making them eligible beneficiaries under the PLC vertical. So we applied, taking into consideration that there is a scheme, it's a government scheme, we applied. Now, the fate of our applications have remained as it is because the authorities are saying there is an embargo because of two orders. We do not.
why don't you go PIL?
Here, my lord, each of these individuals.
You don't have any right as such.
No, my lord,
There is no right as such. How many people are going to be benefited under the scheme? Is it all, each and every one?
Yes.
1 crore, 2 crore, 20 crores, how many are going to be benefited?
So the petitioners who are the.
No,
residents of the-
let us be very clear.
I understand.
You see, when there is a scheme,
My lord.
does it mean that everyone in the state or the country is going to be benefited fully?
It may not be, my
May
lord.
not be.
But
So this bill is going to be for building or building?
building or renovation work.
Building or how many?
The structures which are already there.
How much is the, huh?
My lord, your lordship kindly considers the central.
Who are the eligible persons?
My lord, eligible persons, as your lordship has seen, we have annexed some of the applications. Now, these applications have been forwarded to the concerned
Yes,
authorities.
Mr. Khetria.
Eligibility criteria is contained in the scheme. That has not been annexed.
Oh. Yes,
The scheme of this Pradhan Mantri.
Yes, madam.
Now, so far,
From-
this-
From rows type they have annexed.
huh?
Rows type they have annexed. Rows three is the eligibility criteria that has not been annexed.
that I can, my lord, since the scheme, the entire scheme has not been annexed, that I can predict. my lord.
Mr. Counsel, we are supposed to be fair to the court. Everything should be open.
That is true.
The very purpose of filing this writ petition is what?
My lord.
Is to show that you are eligible
My lord, your-
and that you have got the eligibility criteria.
my lord, eligibility criteria, I'll predict. I'll predict.
Right. The petitioner's case is that the petitioner should be given the benefit of the Pradhan Mantri Awas Yojana dash urban 2.0 scheme. That is housing for all housing. That is construction and
And my lord, renovation.
renovation of houses. However, the petitioner has not submitted has not submitted the eligibility criteria for persons who are entitled to be the beneficiaries of the, under the said scheme. What's up? Mr.
D. Chakravarti.
D. Chakrabarti, land council submits that he will produce the entire scheme on the next date. This is the matter after the week. Mr. Chetia, you also obtain special.
Giving a date.
You get that scheme, no hurry. There's no hurry. There's no urgency. I do not know whether this writ petition can be is maintainable. Will issue notice? Huh? When was he terminated?
My lord, he was terminated 24/3/2008.
2008?
24/2008. Yes,
This is the second time to the High Court.
second time.
First time to it was upheld.
Yes, yes.
Okay, right. Heard, Mr.
Yes, I am.
A. Jahid, learned counsel for the petitioner who submits that the award dated 21/25 passed by the industrial tribunal in reference case number 4 of 2012, wherein the respondent has been respondent number 1. Respondent number 1 has been reinstated with full back wages should be set aside on the ground what is the ground?
Grand Mallet, initially, my lord, the tribunal has to consider the domestic inquiry. But directly
On the on the ground that the learned tribunal did not consider the
domestic inquiry.
the proceedings in the domestic inquiry. First of all, he further submits that this is the second round of litigation in the High Court. And in the first instance, the learned tribunal had, in fact, upheld the termination of the workman / respondent. Issue notice returnable in 4 weeks. Call for the records from the
Yes, sir, definitely.
Industrial Tribunal, Assam, Dibrugarh. Why should it be stayed? That's all.
He is sitting for instatement. The union is stating. You will entitle my under benefit of 17B after filing a petition. The last one was.
Okay, right. In the interim, the impugned award dated 20/01/2025 shall remain stayed till the next date. Issue notice, return petitioner takes steps for service of notice upon the respondent by registered post within 3 days, less the matter after 4 weeks. Heard, Mr.
A. Deccan.
A. Dekha, learned counsel for the petitioner who submits that the petitioner's vehicle hire charges amounting to rupees 4,42,932 has not been paid. Issue notice returnable in 4 weeks. Mr. G. Bokalial accept notice on behalf of all the respondents.
Yes.
Is it all? Are you sure? Police. Police. Correct. Okay. The respondent's counsel is granted 4 weeks time to obtain instructions and file affidavit. Same order. Order amount will be in item 11, it will be 6,65,004, and in 12, it will be 41,38,022.
In item number 10, our name may be reflected clear.
In which one? Item?
10.
In item 10, you say registry to reflect GA Assam in the causes.
Problem is. May I please, Your Honor?
Yes, what is your case?
My petitioner before your lordship is a mining contractor, my lord, was granted mining permit on my lord 15/7/2019. My petitioner received the physical possession of the mining on my lord 1/5/2021. Petitioner has been doing my lord mining work almost 4 years, my lord, without any objection. Suddenly, my lord, on 29/3/2025, my lord, divisional forest officer, without furnishing any written order, my lord, seized 200 cubic meter of sand, which was lifted from the.
You're not mining in your allotted area. That is the view.
No, but after seizing my lord, they send me a soap also, my lord.
Naturally, at least they were lucky to seize it. If you're not mining in your area, then what does it amount to?
My lord, they have to send us
Huh?
one notice, my lord.
The show cause notice has been sent to you.
No, no, after seizing. my
We will
lord.
seize for the lordship.
Yes.
Extra.
But otherwise, if they wait for you to reply,
We'll clear it up.
it'll be all gone.
No, my lord.
So there's nothing wrong. Let the decision be taken. Your show cause notice, have you taken decision?
No, 10/4/2025, we issued a show cause notice.
Yes, so you take a decision.
We'll take a decision. In fact,
Reply to
Huh?
the soap notice, my lord.
So we will direct them to take a decision, and depending upon the decision to be taken, they'll either release your son or you can come to this court. Now it's too premature. How can you challenge a show cause notice? Yes, what is this?
one is show cause notice and one is the report which says that he's been extracting his minerals from another location, which is not in his GPS coordinates.
According to him, there was a flood in the river back here. So
There
I
was
was-
flood in river banking. We asked him to store it somewhere else, but he's extracting from somewhere else and storing it there.
No, my lord.
No, that was his excuse because,
Another government less the term to not allowed.
That was a lot, but he's extracting from somewhere else.
you see, the thing is this, there is a show cause notice issued to you this last month. You have made a reply. You take it,
This is show cause 10/4/2025.
huh? When?
On 10/4/2025.
10/4, that is last month. So
There is
you,
a condition on-
when he needs a reply, he needs a decision fast. He wants to know how he is going to go. His next step will be decided as per your decision.
Yes, sir. Within a period of 3 weeks or less.
My lord,
3 or 4 weeks.
one is the my lord, on 1/5/2007, 1st of May, my lord. That was my lord due date of my kit payment, my lord. That was also disabled, my lord.
What about his payment will depend upon the
Depend on
outcome.
decision taken by the-
Yeah, that will not cause any problem. You want to pay, you pay later.
Impose my lord interest.
Look, first of all, let them take a decision whether their allegations are true or not, or whether your reply is true. Let them take a decision. Right. Heard, mister?
HN,
Yes, sir.
HN.
Learned counsel for the petitioner, who submits that the petitioner has been issued a show cause notice dated 10/4/2025 by the Assistant Conservator of Forest, North Kamrup Division, Range, stating that the petitioner had been illegally extracting minor minerals beyond his mining contract area of NKD-B-15 Nichuka mining contract area, which was in violation of section 41 bracket small a, comma, bracket small b, bracket small d, and rule 63 of the AMMC rules 2030. Next paragraph. The petitioner submitted his reply to the show cause notice on
21/4/2020.
21/4/2025. Next paragraph. The petitioner's counsel submits that the respondents have also seized the sand that had been extracted by the petitioner within his allotted mining area. And has not released the same to him till date. He also submits that the respondent authorities have disabled the petitioner's kissed payment option without following the due process of law. Next para. Mr. R. Gogoi, Senate Counsel for the Forest Department, submits that the respondent authorities shall take a decision on the show cause notice and the reply made by the petitioner within, that's too long.
3 weeks.
It's, why 3 weeks? 2 weeks is enough. Within 2 weeks.
2 weeks.
We have 2 weeks. Huh? What's up? Next para. On considering that the respondents have not taken a decision with regard to the show cause notice and the reply made by the petitioner, this court is of the view that the writ petition is premature. However, as the petitioner had submitted his reply dated 21/4/2025 to the show cause notice dated 10/4/2025, the which authority is to decide? The assistant conservator,
The show cause has been issued by the.
assistant conservator,
Assistant conservator.
by the assistant conservator of forest, North Kamrup Division, Rangya, within a period of 2 weeks from the date of receipt of a certified copy of this order. It is needless to add that the fate of the seized sand and the question of payment of kissed money by the petitioner would depend upon the decision taken by the assistant conservator of forest. That's all. The writ petition accordingly disposed of. Public. I know. Yeah, well, new person. Time is luck. Item 17.
17, my lord, 19, 20, 21, my lord. 4.
Mr. Gupta, I think we had passed some earlier order.
Yes, my lord.
Yes, my lord, but my,
These are the orders, my lord. There were 3 orders I have given, my lord. One is passed by my lordship, and thereafter it was carried through writ appeal, and then my lord, the apex court has.
No, there was an order I passed recently where I mentioned
Yes,
all
yes,
these.
Yes, my lord.
Now, even the Supreme Court order I had mentioned,
Yes.
that is not this is not among them. That one.
Keep it, my lord, sir.
Can you give him
Yes.
the number?
I can give.
Because again, I've got to,
My lord.
combine all the orders. Yes, so what is your case?
my lord, my.
Looks very intimidating, I guess,
Yes,
now.
my lord, I see my lord, that order also, your lordship order, but my case is something
Different.
If your lordship can kindly present my lord, page 37 of my petition.
Page 37.
Yes, my lord, this is the tripartite agreement, my lord, in between the railway and my lord, Gujarat Cooperative Milk Marketing Society, Amul, and my lord, my petitioner, my lord, PB Foods. Through this, my lord, tripartite agreement, my lord, I was inducted, my lord, in the shop, my lord, that stall, my lord, milk stall. I'm a PT businessman, my lord, and that pays 38, my lord.
This Gujarat Cooperative Milk is respondent number?
Respondent number, my lord, 9. That pays, my lord.
And you are who? You are the
I am BB Food, my lord.
BB Food. BB Food. And the first one is?
Is the, my lord, NF Railway Lumbering Division. The respondent. Respondent number 5, my lord,
Yes.
Senior Division
Yes.
Commission.
Yes.
At page, my lord, 38.
For sale of milk and milk products.
Yes, ma'am.
Yes.
Yes, so this, my lord, tripartite agreement, my lord.
So this is for what is the period?
period is for 3 years, my lord.
For 3 years.
Yes, from 14 June 2013 to, my lord, 13 June 2016, my lord.
13 June 2016.
Thereafter, it was, my lord, renewed, my lord,
Correct.
after every 3 years,
No, so it was renewed.
renewed, my lord.
Now, your item comes under which article?
My lord, the impugn order at page 75, my lord. My lord, stall is lumbing at lumbing, my lord. Serial number 1.
Your milk stall comes under which clause of the catering policy of 2010 or catering policy of 2017?
My lord, in catering policy 2010, my lord.
No, yes, catering policy of 2010.
Yes, my lord.
It comes under which clause?
Was, my lord, 16, my lord.
16.
Yes, 16.1.3, my lord.
16.1.3.
my lord. And
And under the 17?
it's renewable clause is there, my
No. The renewable, that I'm not, that is all right. In the catering policy of 2010, there is a renewable clause. That is not denied. The issue is the milk parlor or milk stall is there in clause 16.1.3, correct?
Yeah.
Now, in the 2017 catering policy, in which clause does milk parlor come?
My lord,
It's a minor unit, my lord.
Huh?
my lord, GME, my lord. General minor unit.
My lord, we see clause 16 at the top, 16.1, tenure of major unit.
Now, where is the 2017 thing? The policy, is it here?
Yes, I have. Yeah.
It is a major unit or a minor
It's a
unit?
minor unit.
A minor unit. So it comes under clause 11.2,
Yes,
is it?
11.2 of minor unit, minor.
Minor unit.
Yes.
So it says here, this is 2017.
Yes,
Tenure of food plaza shall be for a period of 9 years. Tenure of all other catering units will be for a period of 5 years only.
yes.
So there will be no further extension renewal except for units specifically referred to in 3.8.1. Now let us go to 3.81.1. All base kitchens under so and so shall be handed over to, Huh?
Yes, my lord.
not related to you.
Yes, my lord.
So your tenure of food plaza shall be for 9 years.
My my lord, on minor units is for 5 years, my lord.
Minor unit.
And
Where is that?
my lord, at 11.2, my lord.
Yes.
Tenure of the all other catering.
Will be
units
for
and
5 years. Correct, 5 years.
5 years.
5
So
years.
my lord, last, my lord, renewed in the year, my lord, 2022. 22, my lord. It was renewed in the year 2022, my lord.
So
But for 3 years, my lord. In place of 5 years, it's renewed of.
no, you see, your earlier the tenure of your agreement
Was for 3 years.
was for 3 years.
3 years.
2016.
Yes.
Then from 2016, it was extended to 2019.
Yes.
But by that time, the 2017 policy had come into play.
Yes, sir. Thereafter, they have renewed, my lord,
They have renewed.
for 3 years.
You were lucky that it has been renewed. It could not have been
Should
renewed.
not have been renewed. My lord.
It should not have been renewed.
My lord, there are, my lord, two submissions in this. One is that by the other railways, my lord, Eastern Railway, I have also annexed, my lord. Malda division has already, my lord, renewed other units, my lord, similarly situated person, my lord. And
May be doing, my lord, but that is not permissible.
You see, just because someone has done something in violation of the catering policy of 2017. Can we allow the same thing to be done here?
No, my lord.
Then
That's correct, my lord. But my submission is that, my lord, I was inducted in this stall, my lord, through this tripartite agreement, my lord. And thereafter, if your lordship come to page 60, my lord, 7, my lord. At page 53, my lord, they have given me the, my lord, at page 53 and annexure 8, my lord. They had given me the letter, my lord, at the serial
Page
number
63.
2. Sorry,
page 63,
page 53, my lord.
53.
Serial number 2 is Sri Biswajit Omik, my lord, contractor Amul Milk Store at Lumding. By DRM, my lord, Lumding.
No, you see, from 2016 to 2019,
I-
extension that is also provided in the 2017 catering policy. Any agreement extending the period prior to coming into force of the 2017 policy, that has to be honored. But then that period has expired in 2019.
My lord, I am submitting, my lord, some other thing, my lord.
Yes.
Page 67, my lord.
67, I thought we
Yes.
were 53.
53, my lord, they have intimated me, my lord, by the DRM, my lord, Lumding, and in page 67, annexure 17.
67.
They again, my lord, wrote a letter to me, my lord, Messrs. DV Foods.
67. Just a minute,
67.
just a minute. 67.
Yes, my lord.
Yes.
They have, the assistant commissioner, commercial manager wrote this letter to my lord DV Foods, my lord, for extension of, for payment of the license fee. My contention is that they have deal with me, but now they have not given me any notice, my lord. Now they have given the notice to Gujarat Mill. And no notice was served to them. If your lordship.
No, you see, the land, who is the lessee of the land?
Lessee means, my lord, there is a tripartite agreement. On that basis, I have constructed, my lord, the stall. And thereafter, I started my business. And no notice was given, my. Therefore, my lord, I am.
Lord, this shop is in the railway premises, owned by the railway. And it's covered by the catering policy. The contract is entered into between the Gujarat marketing Milk.
In page 30 also, my lord.
Federation. Lord, that is
Yes.
that is an agreement with them to take the product. The question here is of the shop, whether the shop can continue.
No, shop can't continue, but you have allowed him to construct.
No. Construction, my lord, is not, whatever is there, that is the, they do it with their expense.
Okay,
You
is something provided in the agreement with regard to that?
Yes, my lord, as page 38, my lord, there is a clause minus 3.6, my lord.
No, I am on the agreement,
Yes, ma'am. In agreement, my lord, page 38.
page 38.
Yes, ma'am.
No, page 38 is not the agreement.
37.
38, my lord.
Okay, yes, page 38, yes,
Point number, my lord, clause 3.6.
3.6.
Clause number 3.6, eviction of the railway premises. The licensee will operate the milk stall during the term of the licensee on which he would have no legal claim other than that of the user. Premises shall be deemed to be a public premises as defined the public premises eviction of unauthorized occupant act 1971. In this regard, my lord, I have placed one judgment, my lord. Judgment. Of my lord, we're meeting.
Hmm?
The judgment is, my lord, I
Not
have
a case
already.
of eviction, my lord. Not a-
This is-
no,
this is-
please,
My lord,
there is an agreement between the parties, my lord, and my lord, if I may say, just one instruction.
my lord, in this, my lord, judgment, it is, my lord,
This license was renewed as a one-time measure. Only as a one-time measure, my lord, although the 17 policy has come into force, my lord, it is to inform that in compliance of the railway board's letter dated 7/8/2020, 7 milk stalls run by Gujarat Cooperative Milk Federation over Lumding division were renewed for one time, and the renewal period is going to expire. Now, they cannot claim it as a matter of right, my lord, otherwise it will be a differential treatment. Because there are several orders passed by this honorable court, my lord, they will also come and now claim that their shop.
No, we,
on that, my lord, before that, my lord, this judgment, my lord, we're needing judgment. It is specifically, my lord, it says in para 8, my lord, no opportunity appears to have been given to the petitioner for showing cause against the proposed action. This is a contrary not only to the law laid down, but also the principle of messenger.
Mr. Counsel, you're bound by your agreement and you're bound by the extensions given to you. What more do you want? You know very well at the time you signed the agreement and at the time you were given extensions, you know exactly what your right is. What can you ask? Even if a notice was given to you, how would it prejudice you? I mean, if it was not given to you, how would it prejudice you? When your rights are already clearly spelled out. And when and especially with regard to this railway lands, it has gone to the Supreme Court and Supreme Court has upheld the decisions of this court. How can we give you differential treatment?
There has to be tender, my lord, where all can participate in the quality.
Maybe if you can go and talk to them sweetly and they give they give you extension not through this court but through your own devices, that's a different thing. But in this court, you cannot get the relief that you seek because it is against the 2017 catering policy, which has been upheld by the Supreme Court.
But therefore, my lord, I am not,
So what can be your now prayer?
here, my lord, limited to the.
We would like to help you, but then unless you show me the way, I cannot. I cannot go against the decisions passed by this court, the division bench, Supreme Court. Clear cut case.
My lord, I will be allowed to go. I will say goodbye to my.
Okay. Mr. N.
N.
Sarkar, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to approach the respondent authorities with his grievance for redressal of his grievance. Mr. N. Gupta, H. Gupta, learned CGC,
My lord.
appearing for the respondent, submits that he has got no objection to the same. Accordingly, he have got no objection to him approaching. That's what I'm recording. No approach, no objection to the same. Accordingly, the writ petition is dismissed as withdrawn, comma with liberty, as paid for.
But I will be for one
Huh?
to eight.
Item number 9. 2021, single. Much.
But I
This
will be
is
for 1 to 8 only. my lord. 9
okay. 1 to 8. 1 to 8. Mr. H. Gupta appears for respondents number 1 to 8. Who's for 9? 9 is the
Nine.
BB. The Gujarat.
Will-
Gujarat. What is this? Could give this back. No, no. I think we'll give this back. I think, what is this? I mean, largest.
Maybe. But 18 and 23 both can be same,
Okay.
same matter, because your losses order will cover.
Okay. Right, heard Mr. P.K. Goswami, learned senior counsel for the petitioner, assisted by Mr. B.P. Bora. Also heard Mr.
I am for petition for what item.
Mr. K. Gogoi for 3 and 5, while Mr. S. Bora appears for 9. Miss 3, 5 and 16. Okay, Miss M can try for 10 to 15. And S can try, huh? And 17. What about the others? What about one Union of India?
I don't think,
Whose name? Mr. R.K. Dev Chaudhary appears for his point number 1, 2. Then who else? Mr. Gogoi, you are for whom? That's point number 4, that's all. Huh? 4. Okay, then arcade stories for 8 also, huh? The, okay, Mr. K over for respondents number 3, 5, 7 and 16. Mr. R going for 4 and 6. Okay. So the impugn order is the same out here?
Yes, yes.
Impugn order is same and the cancellation issued by the same officer.
Yes, yes.
And restore mining operation, that'll be different. Mining operation, to restore the mining operation of the petitioner at Langkang PP Landstone Mining Contract Area. Okay, LANG KHANG. PP Landstone Mining Contract Area. Okay, that I think that is. Others, everything is the same.
Same.
Now, then for the other matter is item
23.
23. Just give me 23. No, the area will be different. Mining area. Mining area
Same, no, no, no. Huh? Mining area same.
is mining area is Nopani. NOPP. NOPANI. NOPANI. PP Landstone Mining Contract Area. Okay. So this is the thing. That's what we need.
Where is the lordship? One of the instant petition below, with a very limited prayer we have come below. And below, after.
Has they made a selection?
Well, we're not aware, my lord.
Has they rejected your bid?
We're not aware. Therefore, we have.
Then
made a
where is the
request-
question?
So the
What do you mean?
departmental council might,
You see, let them take a decision. Nothing has happened. It's like this. It's like you're giving a class 10 examination, and before the results are coming out, you are asking them not to fail you.
my lord, in this matter, I don't, Max.
That is your case, basically.
My
Where's the
suggestion is-
question? Let them take a
As
decision.
per the Milord, NIT Milord, the last is submission of 1st of April and the.
I know,
15th
I
date,
know.
Milord, Opening date, but till date,
They,
Milord,
you
Yes.
said that the EMD could not be verified
And
on that
Milord,
date. Let them take a decision. They might give
our
you.
representation is pending before the authority concerned, Milord. whether
Mr.
we are-
Council, let them take a decision first.
If they take decision, Milord, if you have not been selected to participate. in
Right
the
now,
process,
what right of yours has been violated? Please tell me.
But we're not aware, Milord, whether our bid has been accepted or not, Milord. We're not aware, Milord.
They will tell you. We will direct that as soon as it is. You have taken the decision, please inform. That's all.
Not may I, sir?
Or,
Last date was 2 PM on 1st of April, Lord.
ha,
And it is his own submission
okay.
that it was submitted on the next day, that is on 2nd of April, Lord. 2nd of April was the date of opening technical bid. So it was
Oh,
not before. the
okay,
authority
he
to
submitted it
evaluate.
after the thing.
Yes. For whatever reason, it was not there, not there.
Where is that?
Lordship may kindly see page 19.
Page 19,
Lordship may kindly take from page 18.
page 18, yes.
Serial number 5, Lordship may kindly see. Technical bid opening date 2/4/2025. Serial number
That
5,
take, where?
page 19, Lord, 18, Lord.
Yes.
One table is there.
The bid security shall be deposited through net banking as
No,
per office.
Down below, Lordship, one table is there.
Yes, that is serial number 6.
Serial number 5,
Table is serial number 6.
page 18.
Ah,
Table is there.
correct.
At serial number 5,
Okay,
technical
okay,
bid
okay.
opening date.
Ah, at
Yes.
serial number 6, serial number 5, okay.
Serial technical bid opening on 2/4/2025. If
At
Lordship,
12:30 hours, okay.
Lordship comes to page 19.
19, yes,
Lordship may kindly see 8.
8.
A hard copy of the technical bid submitted online is to be submitted up to 14 hours
1/4/25.
1/4/25 for evaluation purpose for the discrepancy between online bid and the hard copy of the bid. The online bid will govern and will be considered for evaluation. So time was 2 p.m. 1/4/2025. Now, if lordship comes to statement paragraph 3 of the petition, lordship. Page 6. Page 6, lordship, paragraph 3. That the petitioner begs to state
Yes.
that the present petitioner is a rightful and eligible bidder, having complied with all the technical and financial requisites as mentioned, as mandated by the tender, or submitting the bid on stipulated period of time, but being 1st April of the year, it was declared as account closing day, State Bank of India, SBI holiday, and due to such closure of the State Bank of India, the earnest money deposit could not be verified by the Assam portal despite timely initiation and submission of the earnest money by the petitioner, and such obstacle was entirely beyond the control of the petitioner, which prevented the petitioner in completing the tender process online within the stipulated time frame. Although the petitioner submitted the hard copy of the receipt of the earnest money deposit on the very next day, that is on 2nd. So it's its own submission, lordship. It was submitted beyond the last date of submission of tender. So what remains there, lordship?
Correct.
I'll have to submit on this 1 minute. Lordship?
Annexure 3, page 29. My receipt, it's so far as my position of earnest money is concerned. Page 29, Annexure 3, Lord.
Yes.
Yes, lordship will find, Lord, that is on 1st of April at 12:33 p.m. They have fixed for the video at 14, that is 2 p.m. on 1st of April. But prior to that, I have deposited this earnest, this amount, Lord. And lordship, that is done to the Assam e-tendering site on this website.
Huh? You have not deposited.
Yes, my lord, it is the account debited, my lord. This account number and a total amount, my lord, INR account is 4,83,470. It is the total, my lord, that is bid security as well as cost of document. And it's together 4,83,000, my lord. That is on 1st of April, my lord.
No, this is what? This is your payment was successful. Account details, so reference number. How do we know that? Let us see. Where is the NIT?
Yes, my lord.
NIT, what does it
NIT,
say?
my lord, page 13, that starts from page 15 onwards.
Where is the relevant portion regarding the
Yes, my lord, page
submission of
15,
EM?
page 15, my lord.
Page
The
15.
name of the work, my lord, first will find that dismantling the existing structure of the RG Boro Sports Complex, Guwahati. And number down, next, my lord, download of the tender through website.
Mr. Council, let us go straight to the
It is here,
submission
my
of EMD. Where is
Page,
that?
page 15, my lord. It is clear.
Yes.
Last day of online preparation as submission of financial bill, it starts from 26 March to 1/4/2025 at 14, that is 2 p.m. 1st April, 2 p.m. my lord.
Where?
Yes.
So?
First, and accordingly, my lord, at 12:35.
No. So this earnest money,
Yes.
how was it to be submitted?
So, my lord, at page 10, my lord, sorry. At page 22, my lord.
It's page 22. Yes,
Lordship will find 16, bid security.
yes.
Bid security of the amount specified for the work has to reach to the employer as specified ITB clause 16(1.1). The bid security will have to be in any one of the forms specified in detail notifying inviting bid. The bid security shall be deposited through net banking or RTGT or NEFT. As per the office memorandum, the bidder.
The bidder shall
Yes.
upload a scanned image of the bid security with the technical bid. Did you submit this?
My lord, first of all, my lord, as far.
You see, Mr. Council, it's a simple yes or no. You see, when I ask you,
My lord.
did you submit it? I do not want to know anything else besides that. Did you submit it or not? Scanned image of the bid security with the technical bid.
My lord, this security bid, as per the earnest money we had deposited and within time, my lord, at 12:32 on 1st of April, my lord.
Did you submit a scanned image of the bid security with
On
the
sec-
technical bid?
We have stated in paragraph 3, my lord, very next day on 2nd of April, we have hard copy, we have submitted, my lord.
Huh?
After the expiry.
After the expiry, so they did not submit in time.
So Lordship may also come to page 24, Lordship, one specific paragraph is here. It's a general condition, Lordship.
Yes.
Lordship, we kindly see the word general. B, Lordship. Bidding document,
Bidding documents, yes.
additional notes to clause 8, clause 8, Lordship has just now read, Lordship.
Clause 8 is a bidder shall not be permitted.
No,
No, no.
clause 8 is at page 19, Lordship.
Clause 8 of page 19.
The Lordship.
Yes.
Now, this is an additional note to clause 8 of the ITB, Lordship. Lordship, may kindly see this provision, Lordship.
Yes.
Original copy of affidavit, bank certificate for credit facilities, scanned copy of online receipt of EMD bid security, and cost of bidding documents and hard copy of the technical bid are to be submitted before the expiry date and time of the sequence. Online bid preparation and hard submission as given below, tender schedule. So you have to submit it online as well as you have to submit the hard copy before the expiry time on the specific date. And it is his own submission. It was submitted on the base day.
So he did not submit the scanned copy also or the hard copy also on this.
My lord, the reason we have stated, my lord, in
The
paragraph.
reason might be anything. That is no
Your
right.
Lordship, on the similar ground, Lordship, your Lordship recently disposed of one matter, in which case, Lordship, because of delay in train service, Lordship, they could not arrive on the specific place, Lord, at Guwahati for submission of the tender. Your Lordship rejected that thing. I can submit one judgment of the Bombay High Court and of Delhi High Court also. Still,
Show me the.
within the time, the EMD was not submitted.
My lord, in this regard, my lord, I'd like to highlight, and even I have also brought some honorable effects to some citation to, my lord. First of all, my lord, the 1st of April, my lord, it was a.
No, you see, there were other tenderers also have submitted in time.
My lord, the award legal notice and the representation is pending before the concern, my lord. Why they have not replied till then? Why they have waited till then? But the 2nd of April, they have fixed for bid opening. But till then, why they have not opened that bid? Why? No, it's reason aside that when you're not eligible for.
Why don't you give them the reason?
Yes, my lord.
We have not extended the last date for submission.
No. I'm saying, why have you not given him the reason? Why haven't you informed him
Not eligible.
that his bid has been rejected?
Yes, my lord.
But we are not required to reject, Lordship, because not again before the authority for evaluation.
Because of late
Because of
submission.
late submission.
Okay.
Lordship.
So he has given you the reason. That's the end of the matter. And
My learned friend, whatever is saying, that's orally submitting, wherever.
Mr. Counsel, your documents are proving what you said.
My lord, now my
You have
lord,
not denied
what
it.
hindrance on 1st of April, my lord, kindly have a look, my lord.
No, I think
Holiday,
that's
there's a
enough.
holiday,
Right.
No, before that, my lord, I'd like to place some citations, my lord.
You
Under such situation, with the honorable apex court is protected on this term, my lord.
you please give.
Yes, my lord. My lord, I'm giving it. That is the one document I have given with the Reserve Bank of India, that is on 1st of April is a holiday, my lord. The first case I like to rely, my lord. That is the 2005 1 SCC 191, that's a Huda and another versus Dr. Babeshwar Kanhar and another paragraph 5, specific paragraph 5.
Paragraph 5, okay.
Yes, my lord.
What does it say?
May I read, my lord?
Yes.
What is stipulated in clause 4 of the letter to the so-and-so is a communication regarding the refusal to accept the allotment. This was done on so-and-so. Respondent number 1 cannot be put to loss for the closure of the office of Huda that is on so-and-so, so-and-so. And the postal holiday on the so-and-so, in fact, had no control over the same, those matters. Even the logic of the Section 10 of the General Clause Act 1897 can be placed into the service. Apart from the said section and various provisions of the various other acts, there is a general principle that the party prevented from doing an act by some circumstance beyond his control can do so at the subsequent opportunity. That's essential. The underlying object of the principle is to enable a person to do what he could have been done on the holiday, on the next working day, where therefore a period is prescribed for the performance of an act in the court or office, and that period expires on a holiday, then the act should have been considered to have been done within that period if it is done on the next day on which the court or office is open. The reason is that law does not compel the performance of an impossibility.
This is
That-
different, this is with regard to
My
allotment.
case is not the 1st of April, there's a holiday as part of the.
This is not
As per
applicable to
law.
this case. Next
Let-
case,
My lord, same case has been relied by this honorable apex court, my lord.
this has nothing to do with tender.
My lord, 2023 is a tender, my lord. Is a tender from, I have given, my lord. 2023 SCC online Supreme Court 1051, my lord. Paragraph 21, 22, and 23, my lord.
I don't have it.
2023 SCC.
I don't. 2023.
Yes, my lord. SCC online Supreme Court 1051.
I don't know where you are giving, you are not giving. You give me your copy, let me see your copy.
Yes, my lord.
No, I don't. Let me. 2023,
SCC
online, there's
1051,
para,
para 21, 22, 23, my lord.
yes.
21, my lord. This court in Rajkumar so 87 for SEC. The quoting the approving the applying the maxim to the fact of the case of the following say. The other maxim so lex non cogit so. The law does not compel a man to do that which he cannot possibly perform. The law itself and the administration of the aid that such sort of this cause the reference of the alleged infraction of the revenue law must yet be that to which the everything must bend to necessity. The law in its most positive and premonitory injunction is understood to disclaim as it in the general aphorism. The intention of the compelling impossibility and the administration of law must adopt a general exception in the consideration of particular case. Paragraph 23, I'm directly skip to paragraph 23, my lord. And 22, just case law I have relied, my lord. This is Huda, that is discussed, my lord. Paragraph 23, my lord. And paragraph 3 specifically below, my lord, 4. That is done that Kiani versus branch manager Indian Overseas Bank. On that bank basis, if you interpret the law, though there is no power in the court to extend the time fixed by the state, to still the expression immediately is capable of taking within its sweep and situation, where an act is impossible of performance on the day on which the auction was held, but it happened when the bank itself was on strike and no deposit could have been made in the bank, or in the event of the auction sale is held after the court hour. A receipt order in that regard, it cannot be obtained for deposit of such an amount. Such amount could be deposited only after obtaining a receipt order. If next day also happens to be the holiday, the day immediately thereafter coming up, which is the working day, will be the day on which such act will have to be performed. If any of the interpretations given, it will be certified as very object of law. I respectfully submit before the honorable court, Lord, though the 1st of April at 2 p.m. they fix final deposition of the.
You could have always made
And very
the,
second next day, the opening that means as per the citation with the on that day, next day we have.
that was a different thing. Out here, the auction was held after 4 o'clock in the evening. And there was a strike by the bank.
Thank you, Lord.
In your case, you had a number of days to make your EMD.
No, my lord. 1st April, my lord, is the date we have deposited the earnest money. Very second day they fixed it. On very second day we have. given-
As per this annexure page 29,
My lord.
you had, what is this, page 29, you had made the EMD on that date, on the 1st April 2025.
1st April, yes. my
You have
lord,
made it,
That is the holiday in the bank, my lord. It is the
But
holiday.
no, you have made it on 1st April 2025. This is your
Yes,
your
of
document.
1st April within
If
period.
it's a holiday, how was it made on the holiday?
But amount is paid, my lord.
Huh?
Amount is paid. So. Huh? Huh? Yes, receipt verification we have this just because the particular on due to holiday it is closed, my lord.
What was closed? You come to page 29.
Yes,
Just
my
come
lord.
to page 29.
Yes, my lord.
Come to this date at the bottom. 1st April 2025. What is this?
Yes, my lord. As per learned friend, he's saying, my lord, the verification report we have been received on very second of April, that's because on first of it was closed. The bank was closed, my lord.
Mr. Counsel, you please come to this. What is this 1st April 2025? What is this? At
First
page
April,
29.
First April, 2025, 12:33 IST, deposited. As per, this amount is carried, my lord.
Huh?
This amount, on first April at 12:20, the amount we have given, it is carried out not regarding the, huh? The NFT down there, it is the screenshot, my lord.
Mr. Counsel, what is this document? What do you want to show with this document?
My
This date. Please don't try to,
Yes, yes,
now,
yes,
you know,
yes, yes, my
try
lord.
to color it
Yes,
with,
yes, yes, my lord, yes.
you're going round and round and making yourself deeper into the quicksand. Anyway, 1st April 2025.
My lord.
What happened on this 1st April 2025 at 12:33 Indian Standard Time? What happened? Mr. P. Nayak, come to page 29, that last portion, page 29. At the bottom, second last line, can you see? 1st April 2025, 12:33 IST. Now I want to know what happened on 1st April 12:33. Why have they given this document? I want them to think. Yes,
The amount is credited.
amount is credited on this date, at this time. To whom? Amount is credited from where?
Assam tendering site.
Huh?
Assam tendering site.
E-tendering side. So that means it has been credited from your account to them. Then I just now, they, huh?
Bank valuation copy could not submitted because the 1st of April, bank is closing there.
But how can it be credited if it was closed? If the bank was
Nifty,
closed,
the amount is credited through the through online.
it was credited online.
Very next day we submit the hard copy.
Hard copy.
It was credited online. Through your net banking.
Net bank.
And we could have submitted, you know, had it been not a holiday, because the first closing date on 1st April. That is the problem. On very next day, we submitted hard copy with this bank statement. So repeatedly, we have made legal notice representation, the setting silent, whether I'm eligible to participate in the tender process or not, my lord. I could not take any records.
Where is the statement of accounts, the bank statement of account?
Thanks. It would debit account. Account, this is.
Debit account.
Yes. In page 29, it's very much reflected debited account, my lord.
Mr. Counsel, what do you mean very much reflected? There, do you know what a bank statement of account is? Don't say the first thing that comes to your mind without understanding the question or without knowing what a statement of account is.
My lord. Your payment was successful, that account details, reference.
Have you ever seen a statement of account?
Yes, account. Reference number is this. Well, bank statement we have not enclosed here. Bank statement of no, we'll submit banking statement.
That will prove
Yes,
whether
because- yes.
but the only problem is it was not done. This, Mr. Nayak.
The only problem is it was submitted beyond the last date of submission, one. And secondly, Lordship, it was only because of his own negligence and laxity, Lordship.
That may be, but then what he's saying is that on that day it was a holiday.
Lordship, on similar circumstances, court has already decided.
Give me the judgment. Otherwise, we'll fix it for another day.
Lordship, we'll pick up this matter on Monday, Lordship.
Monday, I'm not coming. Sorry.
Thanks. In my humble understanding, Lordship, nothing remains for placing of citations also. On facts also.
I'm not as fast as you. I'm slow. I've got to be very careful. I have to write orders. For you, you just have to give submissions and then walk away. For me, if the orders remain and then tomorrow somebody else will come again against my order, you know.
In the Delhi case, Lordship, it starts from paragraph 12,
12, yes.
Delhi High Court. We should take it. In this case, Lordship, the EMD could not be deposited because of some technical glitch.
And what about this other case?
Same law, same issue. So
No, where is the reasoning given? You see, because in the Delhi case, it says that it was not due to the fault. No, it was due, it was the because this is the failure of the bidder to submit censor within due time on the e-portal is certainly the fault of the petitioner itself. So now the question I'm going to look into is whether it was the fault of the petitioner.
now, Lordship, that the first of April will be a bank holiday, Lordship, or it will not be open for public transactions. That is not a secret, Lordship. This is not sudden. Suppose Monday is a holiday, we are all aware that Monday is a holiday. It is not sudden, Lordship. 1st of April will always be a day, Lordship, will not be open for public transaction. That is a known to every businessman, Lordship. So that is why I'm saying, Lordship, it was his own negligence.
Anyway, so what is your prayer in the writ petition?
Our prayer is page 9, my lord. Two prayer we have made, my lord. And another is consideration of our representation, my lord.
Look, the first one cannot be done.
The representation may be directed, my lord, dispose of.
You take a decision on the petition.
It's not already disposed of, Lordship. I'm not.
If not already.
Yes, my lord.
Right. Heard Mr. P.K. Deka, learned counsel for the petition, who submits that the petitioner had submitted his bid pursuant to the notice inviting tender bracket NIT dated 24/3/2025 for the work of inverted commas dismantling of existing structure of the RG Barwa Sports Complex, Guwahati, SM with an estimated approximate value of work of rupees 2,54,48,453. The last date of submission of the bids was 1/4/2025 before 2 p.m. Next paragraph. The petitioner's case is that though the petitioner had submitted the bid security amount bracket earnest money deposit bracket close prior to two p.m. on 1/4/2025 by way of net banking, and the amount had been credited into the account of the respondent number 4, the scanned copy of the and hard copy of the EMD could be furnished to the respondent authorities only on the next day. That is on 2/4/2025. Comma, on account of 1st of April being a bank holiday. Comma, for the bank holiday. As it was declared a account closing day.
Just one line, I'm sorry, but just one, if Lordship comes to the representation law,
Page.
33.
Yes, yes.
Lordship may kindly see what he is claiming now, but
Yes.
it's demanding. Down below Lordship in
Yes.
bold Lordship. Immediate cancellation and retendering of the tender process. So that prayer Lordship, we cannot,
Yes, Vinod.
I mean, in my humble understanding, we cannot
Yes.
consider that prayer at this stage.
Yes, Vinod.
So
It
we
only
just
prevents-
take a decision and we
So
just,
to the extent of evaluation of his tender Lordship, to that extent Lordship at this stage we can consider.
you can evaluate. You can evaluate and take a decision as per your discretion
Yes, Lord.
to whatever you think is proper. Just because he has asked for the moon does not mean that you'll give him the moon or you'll consider it. You'll consider it to whatever you think is correct. Why you are scared that the authorities will go into whatever has been stated here?
I agree to your thought. This submission should have been first, it should be decided whether my tender is going to be valid or not.
Correct.
That should have been the first.
Correct. His prayer actually,
Something else.
you are praying something else. That also you are very smart. You're not being very straightforward. So what have I said? So, sir, he submits that as it was not the fault of the petitioner in not being able to get the hard copy of the earnest money deposit from the bank on a holiday, comma, the petitioner had to submit the same on the next day only. Next para, Mr. P. Nayak shall obtain instructions as to whether the petitioners, as to the status of the NIT and whether the same has already been, whether the tender has already been awarded to somebody. He shall also obtain instructions as to whether the petitioners. No, we have already said that. And before that, you right, Mr. P. Nayak, Learned, the additional AG submits that the petitioner's bid could not be considered as the petitioner had submitted his earnest money deposit in the hard copy of the earnest money deposit and the scanned copy only has, after the last date of submission of bid. And as the same was in violation of the terms and conditions of the NIT, the petitioner's bid was not considered. Correct?
That Lordship, I'm not saying.
You don't know. That's what you said.
Yes, Lord. That instruction I will take, Lordship, whether
Okay.
it was done. It
Okay.
was not before the authority.
Okay, what have I said, Mr. P. Nayak? No, this is.
Lordship, I'm
The
submitting
Mr. P.
it.
Nayak, Learned Additional AG submits that the petitioners, that the petitioner in his writ petition has clearly admitted to the fact that the earnest money deposit had been made. The hard copy of the earnest money deposit had been made on the, one day after the last date of submission of bids.
And it was not available before the authority. for
And the same was not available with the authority.
consideration.
No, it would be that too, because on that date it was considered. That part, and it was cut that, huh? Full stop. Mr. P. Nayak shall obtain instructions with regard to whether the, whether any uh, tenderer has been selected pursuant to the NIT. List the matter. When? Too short. Give some other. Friday.
Tell me not some protection, otherwise.
No protection. That's the 1st April. Today is, what, April? What? Yeah. I was thinking of dismissing your case earlier.
May I please, Raksha? Raksha, we have submitted. the
Item?
30.
Yes.
My lord, I have received the affidavit in reply today, my lord. So, proceedings complete, my lord. Settlement fixed for admission hearing on hearing date.
What do you want? You filed your reply today.
Yes, I have received today.
Okay, right. Mr. S. Data for the
For
PNRD.
the respond number 3 and 4, my lord.
with point number 3 and 4 submit that he has received the reply affidavit today. What's up? Miss
A.H. Atya.
A.H.
Atya.
Atia, clerk counsel for the petitioner and Mr. S. Data. Pray that the matter may be listed after.
I am praying for 3 weeks, my lord.
2 weeks.
Listed after 3 weeks. List the matter. This matter pertains to for what?
Allotment of Vita, my lord.
Huh?
Allotment of marketplace, my lord. Vita, it's called Vita.
List the, give a date. Or end of this year, end of this month.
3rd June is for my lord.
End of this month.
She is in a hurry.
My lord, actually, I have to collect the repetition also. I also reconstruct the file.
28th,
My lord.
28 May.
Much obliged.
Hello.
We have sent the affidavit for vetting.
Okay. Ms. DJ submit that the affidavit has been sent for vetting and the same will be filed within
1 week.
1 week. This is the matter after review.
Always.
Please, Your Lordship. As per last order, Lordship, the case supposed to decide by PTC in his EC meeting on 2/5/20.
Look, yeah, the court has directed you to do it. It is not a question of you accepting whether to do it or not. You have to do it.
The direction was to verify and they paid record after. The verification was done. When it found that the supply has been made. Now
Ah,
the
the-
supply has been made.
Huh?
Verification has been done. And they have supplied that verification.
So how much is liable to be paid?
Which is that is around 11 crores plus, 11 crores this plus. So after that, they in a meeting, they said that it will be paid. And the SOPT fund.
But this does not say that. This does not say that you have made a verification. This only says that you will make
Is
a.
already there.
Huh?
Verification is there. FDP is already there. This doesn't say, but the FDP is there. Verification is there. They have received it. And now the when the meeting took place in on 2/5, they have decided they have to pay. And that SOPT funds is coming, then we'll start paying it as per.
Where have you said that in your affidavit? Let me see.
Lordship takes up my affidavit, my lord.
Affidavit of,
Affidavit filed on 9/3/2025.
by whom?
Lordship by the respondent, my lord. That's one number 2. The principal secretary itself.
10th March 2025.
10th March 2025. If Lordship stands to
there is a minutes of the meeting. It starts from page number 48. The team has visited and found to find out
What? 48? 48 is the
48 annexa 4. 48. So running page number 48. madam.
running page 48 is the affidavit. This is the thing. 48 is this. 48 is this.
That's a 58. 58.
53. Okay, yes. Yes.
So as per the
Listen, annexa 4, my lord. There is a minutes of meeting dated 12/12/24, my lord.
And extra 5, and extra 4.
4, my lord.
Yes. That is page
Every day visited the spot where the subject is
59.
15.
Huh? 58.
Why some pagination is defective? Why it is 48? This is annexa 4.
start from 58.
58 and extra 4 minutes of the meeting.
Minus dated 12/12/2024.
Yes.
So the inquiry was made, whether the supply was made, supply was done or not. Everywhere the inquiry just found that the supply has been done. And we find out that the supply has been done, they have received it, and it has come to like that. All the material which we need to supply has been received. This inquiry was done. And subsequently, subsequent to the inquiry has been done, the supply, now you have to pay. That's why in the meeting,
So how much have you got to pay? Where is the amount?
the amount, point of specific amount is not there. my lord.
Why?
Lordship, amount is 11 crore 41 lakh.
Where do you get that? Where do you get that? That is your figure.
Yes, Lordship. Radman ko bhi there, Lordship.
Huh?
Order ko bhi there, Lordship. There is still mentioned.
In the judgment it is
In order,
mentioned.
Lordship.
In the judgment it is mentioned.
No, in the order, it is
In order, Lordship.
In which order? Order by whom?
Lordship, by this is read petition, Lordship, in read petition.
Read petition.
Yes, Lordship.
page
Number
number
35.
35. There are two amounts, my lord. 6 crore something, 6 crore 89 lakhs, 87 lakhs, 14,442, and 4 crore 9 lakhs, 6 rupees. Total it becomes 11. There are two orders. Page number 35, paragraph number 3.
6 lakhs and 4 lakhs means
No,
more than
not
10 lakhs.
6 crore. 6 crore, my lord. What?
Yeah, I know. 6 crore it means more than 10 crore. In fact, it means
It
it
should be
is.
11 crore something.
Huh?
11 crore something. Total.
It is not 11 crores. It is around this little less than 11 crores.
Whatever, whatever.
11 crore 41.
But where is it? So where is your admission to the amount?
Well, that particular letter, my lord, just now I have given that communication, my lord. It clearly said that with reference to the subject cited, I am directed to say that the BTC Executive Council in the meeting held on 2/5/2020 had decided that payment of the contempt petitioner shall be made in terms with considerably the state of so and report and so and so. The amount has been admitted now. They said this amount.
Where is the admission of the amount?
In affidavit, Lordship, in read petition, Lordship, kindly come page number 7. Lordship.
Mr. Counsel, I am not bothered about your repetition. Or I want their affidavit, not your affidavit. You can say anything you want.
They are
Huh?
affidavit, Lordship.
You are reading their affidavit.
Yes, Lordship.
Which
Paragraph
page?
number 7, my lord.
Page number
Whom?
6.
Affidavit of whom?
That's respondent number 2. Yes, respondent number 2. That about the inquiry. Para 7, my lord.
So where is it that the amount has been accepted? We are not playing around with this code.
So the inquiry committee has received it and they have been verified, my lord.
Where is that? I want the figure.
Amount, my lord.
Naturally.
Well, amount, I have checked it, my lord. Amount is not specifically given.
You have got to give the amount.
Amount has not been specific.
You have got to give the amount. saying that he made the supply. Have you said that, where have you said in your affidavit that you have, that the claim made by the petitioner with regard to the amount is admitted? You have only admitted to the
Receiving of that.
receiving of the supplies. But what about the amount that is payable to him?
Specifically, nowhere it would say that amount is payable, that this is the amount total payable to him.
When he has made when he has given figures, it was your duty to check whether the figure was right. Then,
Only said that the amount is amount.
oh, you please tell this respondent number 2 to come up with the answer next date. Otherwise, he has to come here.
Lord,
I will ensure that he comes here.
so that, Lord, nothing bit specific on that amount.
Yes, right. Next para. Right. Heard Mr. J.U. Ahmed, learned counsel for the petition, and Mr. S. Bora, learned counsel for the respondent. I think your secretary should come here.
No,
Should
Lord,
come and pay this
once
court.
that's final late, then,
I think he should come. This 2022. They are playing around with this court.
no, Lord, it's specified that the.
Order is of 2021.
Lord, it's specified
2021.
what is the amount due, my Lord, then thereafter, my Lord.
Right. This court, in its order dated 24/11/2021, passed in WPC 2950/2021, had directed the respondents to verify whether the claim of the petitioner regarding the non-payment of bills amounting to rupees 6,87,14,442 in respect of work order dated 7/3/2020 and rupees 409,000,006. 409,000,006
I have calculated it, it does change.
in respect of work order dated in respect of another work order.
Same work order, bill, two bill is there.
Oh, in respect of the same work order. And pay the petitioner the admitted amount expeditiously. Pusta. The respondents have respondent number 2's affidavit is basically to the effect that the petitioner has made supplies as claimed by him. However, the respondent number 2 has not made any admission with regard to the bills with regard to the amount due to him. Accordingly, the respondent number 2 shall specifically state the exact amount of money due to the petitioner by the BTC, Pusta. The same should be submitted by way of an affidavit by the next date, failing which the secretary, who is he?
Principal secretary.
The principal secretary, chief executive officer, BTC, may be asked to appear. Pusta. This is due to the fact that the order of this court has not been complied with, even though more than 3.5 years have lapsed from the date of the direction passed by you. List the matter on when?
On 2/01/20.
Huh?
20.
You get the exact date and affidavit has to be filed. It has to be filed. Otherwise, he'll have to come here.
Yes,
I'll make sure.
Second of June.
You, second of June.